So one of the questions that counsel has to ask themselves relates to the presence of your client's name in the indictment. And the first, simplest question is related to personal jurisdiction. Does the court have personal jurisdiction over my client? Meaning, can or should my client be brought to answer charges before this court? Now, personal jurisdiction is established when the defendant is brought before the court by proper criminal process. And what do I mean by that? Proper criminal process can be a summons or a warrant, an arrest warrant. Now, while you are unlikely to find a fatal flaw, meaning some flaw in this process that's going to get the case thrown out, especially one that can't quickly be remedied by the government before your client, leaves the district, you should still, nevertheless, be on the lookout for any significant errors in the criminal process that's brought your client before the court. Now, since we're talking about cases that have been indicted already, that means that a grand jury has charged the defendant and issued an indictment. That means there's not going to be what's called a preliminary hearing at which you, as the defense attorney, can explore and challenge probable cause to charge your client. That's already been covered. But that doesn't mean you can't begin an early challenge to the evidence or the strength of the evidence, because one of the considerations the court has to undertake at a detention hearing is the weight of the evidence against the defendant for whom detention is being sought by the government. So if you have a case where your client's been indicted and the government is seeking detention, meaning they're going to be held in jail while the case is pending, you can have a detention hearing and get good testimony on the record about the scope of the allegations against your client, the different types of evidence the government may have supporting those allegations, and that early testimony can be invaluable because at this stage of the case, which is very early on in the first couple of days, you haven't received any discovery from the government. So this is the first potential challenge to the indictment, even though it's really couched in terms of detention. That's the first real challenge that's available to you if you're not going to have a preliminary hearing.